Hi, everyone. My name is Deana Pollard-Sacks, and I come today from the Thurgood Marshall School of Law in Houston, Texas. I'm also very grateful to be here and honored to be a part of this fabulous group of scholars. And I'd like to offer a special thanks to C-SPAN for bringing this from the academic realm to the public. My presentation today is entitled Delusions of the Mind and Twisted Behavior. Implicit bias is delusional thoughts. It's untrue ideas about people within the mind that manifest in unfair behavior. The word tort itself means twisted. It comes from the Latin root meaning twisted. So a tort means twisted behavior, antisocial behavior. And this is what can result from implicit bias and does result from implicit bias every minute of every day in our society. I decided to hone in today on a true example of implicit bias that happened to someone who I know very well in the legal academy. I'm going to call him Rico, and hopefully no one will know who I'm talking about, because the last thing I want to do as I argue here for expanded tort liability is invade my friend's privacy. Rico is a strikingly attractive Mexican-American man. He is the epitome of Hispanic good looks. He is tall, dark, and handsome. Rico graduated from one of the top law schools in the country, a law school just like Harvard, and decided he wanted to become a law professor. So he went out in the market and he gave a presentation at a law school and did a very good job from what I hear. I was not there. But when the faculty opened discussions about him, a number of the women objected to hiring him. The women said that he made them feel uncomfortable. They said that he seemed conceited, and the word womanizer was raised. This is a married man with children. And the conceited thing I found just fascinating, because I was looking into stereotypes as part of my book chapter and came across an article that said that the #1 stereotype applied to attractive people is that they're conceited. I would have guessed that they were stupid, but the #1 stereotype is that they're conceited. I can tell you from firsthand experience, I have a lot of really attractive friends, and they are the least self-assured people I know. And when thinking this through, I thought, you know why? It may be because people expect them to be conceited and treat them with hostility, and they end up with low self-esteem. But putting that aside, I can tell you point blank, Rico is not conceited. Rico is salt of the earth. He is one of the nicest people I've ever known and has been a great source of support for me personally. So in talking about what happened to Rico, I'm going to focus on 3 questions. One is a causation question. How did this happen to him? How did such a nice guy get characterized in a way that's so untrue? The second question is the normative one. Should we use tort law as a way of addressing this, or should we leave it to just public discourse and private discourse? The third one is a practical question. If we accept that tort liability is a means of addressing this problem, how do we do that? So to the first question, how did these stereotypes about Hispanic men lead to Rico's rejection as a law professor? And before you get too sad, I will say someone stood up and took exception to what was said about him, and he did end up getting a job in the legal academy, in part because someone brought up the fact that they thought he was being stereotyped. But back to the question, why did these women not like him? Well, what did he do? What did he say? When pressed, these women had no answer. But most of us are aware that the Hispanic male stereotype conjures up images of, machismo, sultry, sexy, chauvinistic. This is where I think it came from. Rico doesn't have those characteristics, but because his Hispanic good looks are so salient, I think it just brought in the flood of assumptions about what kind of person he is, even though they didn't match the content of his character at all. And I think it happens all the time. I think his biggest crime was showing up cute and Hispanic. And that was all it took for these stereotypes to come flooding in and for him to be rejected as a candidate, despite being a fabulous candidate. So the next question is the normative one. Do we want tort liability as a way of addressing this problem? A tort is an act of civil wrongdoing. Tortious behavior literally means twisted behavior, wrongful behavior, antisocial behavior, behavior we want to stop and quell, perverse behavior, as opposed to fair, just, honest, and honorable behavior. Tort liability is the barometer of minimal civil expectations. If we fall below that, we can be liable. We can be sued, and we can pay money damages. Tortious behavior is bad because it hurts individuals, but it also hurts society at large. And this is why we have punitive damages, for example, to make sure that it goes beyond the context of an individual lawsuit and goes out to society and deters others, because they're going to probably hear about punitive damages. Punitive damages are usually the greatest amount of damages in a lawsuit. Prosser and Keaton refer to tort law as a battleground of social theory. Scholars agree that tort liability is extremely flexible, and it responds to social problems. Now, since the mid-19th century in our country, starting with a case called Brown v. Kendall, we have revolved tort liability generally around a principle of fault. In other words, you must prove that someone did something intentionally or at least negligently to pin them with liability. But that's begun to change. In the mid-20th century, with the advent of strict products liability, for example, we as a society decided that it wasn't so important to prove fault. It's more important to make sure we have good social policy and to assure compensation to victims. So we've already begun to depart from the fault principle over the years, and I think it's happening more and more. A number of courts, and I discuss this in my chapter, have departed altogether from the idea of a duty of care. They said, well, when we see behavior that is just so wrongful that we can't tolerate it, we're not going to worry about the first element of negligence. We're just going to go ahead and bypass the duty issue or say there is a duty when there really wasn't one. And a quick example of this was the first case out of California in '83, where a bartender just refused to allow a non-patron to use the phone to make a 911 call, an emergency call. Another non-patron was being beaten to death outside of this bar, and the bartender said, I'm not letting you use my phone. I don't have a duty to you. I'm not sure he actually used those words, but that was the idea. And the court in California said, we don't care, basically. What he did was so wrong and so antisocial. The man died. He was beaten to death, possibly because the bartender wouldn't let this non-patron make a free call. So see, courts are starting to see that we need to watch what we do with tort law in order to make sure we are continuing to construct the kind of society we want. Now, the turn of the 21st century ushered in another idea about law, and that is law as expression, law as a norm-regulating function, a tool of social engineering. And again, this is a way of sort of looking at tort liability differently, not so much based on fault, but maybe based on the idea that when people understand that something is wrongful, it may influence the way they behave and may change their norms. My favorite example of this is a law in Sweden. In 1979, Sweden was the first country in the world to ban parental spanking in the privacy of one's home. And the Swedes were pretty upset about this at the beginning, but after time, they accepted it, and now they wouldn't have it any other way. The law had no penalties. There was no criminal penalty, no civil penalty, but it worked because it got people to think about it. And just thinking about it and talking about it, it changed the law. It changed the way people behaved without any penalties. So this brings us to the last question. Assuming that we believe tort liability is a way of addressing this issue, how do we do it? Well, implicit bias can't constitute a tort per se any more than an unspoken thought can constitute a tort per se. So I think the only way we can do this is to use a predicate tort, and then if we can show implicit bias caused that tort, allow enhanced remedies in some ways. So one example might be punitive damages. Again, not so much about fault, not so much about punishment, but about exposing the seriousness of this problem by making big damage awards that will catch the media's attention and spark public discourse. Get people thinking, get people talking, get people to see that this is not much ado about nothing. This is very serious. Implicit bias causes serious injury to people, loss of job opportunities, loss of life sometimes in the prison system. And so it is a very serious issue that needs to be taken seriously. Now, the other thing that I thought might work is equitable remedies. In Rico's example, for example, I think what happened there was the hiring process in law schools is so subjective and often arbitrary. We don't have set rules. We don't have forms we need to fill out. There's this blind voting, which is ubiquitous in our academy, which I disagree with. I think that when you do things in a subjective manner, that's exactly when implicit bias comes into play. Whereas if you have more objective means, it sort of forces people to think through why they're voting the way they are. So maybe, in a situation like that, if Rico were to bring a claim, maybe a court could fashion a remedy and tell the law school how you must hire. You must look at people's academic background. You must review their scholarship record. You must create some kind of quantitative analysis of why you're hiring, who you're hiring. That's one way of possibly dealing with implicit bias and making sure that these delusions in one's mind based purely on a person's physical exterior don't end up costing that person, a lifetime of job security and millions of dollars, because that's what a tenure track position is. It is a multi-million-dollar contract, a lifetime of security and prestige. And so I think that realistically, tort law could be used as a means of addressing unconscious bias. It's unfair, it's ubiquitous, very few people know about it. And if we did allow some liability, it could provide both remedies to the victims and also spark debate and get people thinking about it and talking about it and possibly lead us to a more fair society for everyone. Thank you.